This video will introduce you to the parts of a case and provide some hints on how to read one. This case is as it would appear on an electronic database or, for the most part, in a print reporter series. Reporters are the sets in the library that contain decisions from a particular court. So I'm going to walk you through the parts, and then we'll talk a little bit about how to read the actual opinion when we get to it. The first thing I want to point out is what's called the citation, and that's this. You could put this number into either of the electronic databases, Westlaw or Lexis. You could probably Google it and find the case. Sometimes this will be helpful to you when you are reading a case for one of your doctrinal classes and you're not fully understanding it because of the way it's been edited. Texts are edited for casebooks so that they only really talk about the parts that are pertinent to that particular course. So in your torts class, you won't be seeing a lot of discussion of any contract issues that were part of that case in the real world. You will only see the aspects of the case that pertain to torts. So sometimes in the editing process, necessary information is omitted. I'm trying to figure out, there we go. I'm new to this. You'll have to forgive me my novice attempt at doing this video. So that's the citation. This tells you who decided the case, the Supreme Court of Kentucky. This is the case name. It tells you who the parties are. The highlighting, the internal highlighting, is because those are my search terms, Kraft v. Rice. And then this is when the case was decided. This information is a summary of what the case held and how it got to the court. It also tells you the result and how many of the justices agreed with this. This information will never appear in one of your casebooks for class. That would make life far too easy. These are editorial additions. They are not any part of the case. These headnotes, these numbered paragraphs that you see here, this case has only 3 headnotes, which is a relatively small number. Cases can have up to hundreds of headnotes. These are, again, summaries of parts of the case. Sometimes you'll have a holding, not always. And they are not part of the opinion itself. They are editorial additions as well. Then you have the information about who the attorneys were, and then finally we get to the opinion. The first thing you will usually see, and this is your clue that you are about to start into the opinion itself, is someone's name. This is Justice Wintersheimer. He is actually an adjunct here at Chase, so you may be lucky enough to take his Kentucky Constitutional Law class in one of your upper level years. Then you start into the opinion itself. Oftentimes, the court will give you the procedural posture, which is what is going on in this particular paragraph. This first paragraph tells you how the case came to the Kentucky Supreme Court. And it's very useful to you. You won't have civil procedure this year, so it's very useful to you to pay attention to this so that you understand how the case got here. When you see a term with which you are unfamiliar, which I think you have in this paragraph, look it up. Directed verdict. Do you know what that is? What's a statute of limitations? Look those things up. Don't just assume, well, I don't need to know that. You do. When you see something that you can link to, it's tempting to click on that link. Don't. Your reading will take you long enough without doing that. KRS stands for the Kentucky Revised Statutes. This is a section number. It would take you to the statute of limitations, but the court is telling you what you need to know about the statute of limitations, so there is really no reason for you to click on that link. This is a very nice thing that Justice Wintersheimer does for people. He starts his opinion with, the crucial issue is. This is not always going to be the case. You will find, more often than not, you are having to figure out what the issue is on your own, and you will develop the ability to do that as you go through law school. Here we have a nice statement of facts, and then we go back to a little bit more procedural procedural posture here, and it's telling you what the plaintiff's claim was. Then a little more procedure in this paragraph. Again, you have two cases here. You could link to them if you are looking at the case in an electronic database. Don't. You don't need to know everything that these cases say, and these cases would only link you to other authorities that you would then follow, and that's a rabbit hole. Don't go down it. The court will tell you what it needs you to know about anything that it is citing. So that's just one little tip. Here's the result in the case. This court reverses the decision of the Court of Appeals. Okay, so that's what's happening here. This court is reversing, and here is its reason. And then here, where you see this little 1, this corresponds to that thing that I called a headnote on page 1. So this is where the summary that appeared in headnote number 1 will appear, and you will see that those numbers are always bracketed. So here is a discussion of the plaintiffs, also in this case known as the movant, what they are claiming and on what basis. Here's another phrase that you need to know. What's a cause of action? Look that up as well. The court in this paragraph here is still summarizing the plaintiff's position. And I'm going to continue to call the Crafts the plaintiffs because that's how they started the litigation, and it's easier, I think, to keep straight plaintiff and defendant than it is movant and respondent, which doesn't tell you as much. So here's some again claims of the plaintiff, and then this is where the court starts its analysis of the situation. There's an absence of definitive authorities. What this means in this case is Kentucky doesn't have this tort. Kentucky has never recognized this tort. And one of the reasons that we chose this particular case for you in LAPS is to show you how the common law develops. So this is really a great window into how courts make law, and courts do make law, which you will learn in the course of law school. If you didn't know that before, courts make law as well as legislatures. So this is how a court would go about doing that. This is how the Kentucky Supreme Court did it. So what they do, what Justice Wintersheimer and the justices who agreed with him that this was the right result and signed onto this opinion, what they did, they went through a number of other jurisdictions and discussed what they had done with this type of a fact pattern where somebody did something and the wrongdoer's conduct was really horrible and the emotional distress that was suffered was severe. And they go through Virginia. You can tell by the citation. This tells you that this is a Virginia case even if the court hadn't. Michigan. This is only a court of appeals. This is a secondary authority. You will learn to recognize these. This is a statute. North Carolina then they go into as well. Then we admit, here's where the court is saying what I just told you, that, gee, Kentucky doesn't have this tort. We've never recognized it, so of course we don't have a statute of limitations for it because we've never even recognized it. Then they go through some analogous cases, or they think they're analogous cases. These are grave desecration cases where someone was injured by a loved one being disinterred for some reason. And it's not really close, but it's as close as they could get, apparently. And the court admits courts' jurisdictions are not unified as what statute of limitations should apply. And then they go back to that topic, not so much on whether the tort should exist, but on if it does exist, what should the statute of limitations be. Now, if you were reading this case for a torts class, you would know that your focus should be on the elements of this new tort that the court is about to recognize. I'm giving away the ending, but you would know that that's what's important for you in reading this case. And you wouldn't be quite as focused on the issue of what statute of limitations should apply as you would be on what are the elements of this tort. So, in addition to the grave desecration cases, the court goes through a number of other types of cases that they say are roughly similar, cannot completely correlate, but they're similar. Then the court does something that's a little bit unusual, and it tells you its opinion of the behavior in this case. It tells you what it thinks about what Mr. Rice did. And it is an unqualified opinion here, which might explain the overall result, which I will tell you at some point, maybe not in this video, but maybe during class. The court decides to adopt the Restatement Second of Torts version of a tort, so that Kentucky will now, for all cases in the future, have a tort that recognizes that someone who is hurt by, as the language is pretty clear here, someone who is hurt by extreme and outrageous conduct and suffers severe emotional distress as a result can recover from the wrongdoer, the person who engaged in that conduct. So, the tort now exists in Kentucky after this case was decided, and it tells you a little more about why it's doing this, and then we go back to the procedural posture and we repeat that the decision of the Court of Appeals is reversed and it's remanded to the Circuit Court for trial. I guess I won't hide from you the fact that it never came to trial, as far as I know, with the Supreme Court giving such a clear indication of its belief that this was extreme and intolerable. I'm fairly certain that the defendants settled, rather than go to trial and have a jury decide how much money the Crafts should be awarded. Then, at the end of the opinion, you see who concurred in this result, and then you see who dissented. A dissenting opinion is someone who is written by someone who disagrees with the result, and this justice also disagreed, and the seventh justice did not sit on this case for some reason. Usually there's some sort of a conflict, perhaps. Before becoming a judge, Justice Vance had worked for one of the defendants, or some reason he is not sitting in this opinion. So, this is the dissenting opinion. In your casebooks, if a dissenting opinion is included, you should read it. It is there for a reason. Even though it is not law because it is only a dissent, it's important for some reason, and you can't skip it. The other type of opinion that you can have the majority opinion, which is the one that Justice Wintersheimer wrote. Then you've got the dissenting opinion that Justice Stevenson wrote and Justice Aker joined in. There is a third type of opinion called a concurrence. A concurrence is someone who votes with the majority on the result, but disagrees with some of the reasoning, or may disagree with part of the result. You can have a concurrence that says, I agree with the court's opinion on parts 1 and 3, but not with part 2. So, if ever in your casebooks you have a dissent or a concurrence, know that you need to read that because it's there for a good reason, and your professor will expect you to know what it says. Okay? And that is the end of this first video. Thanks for listening.